Hello everyone, welcome to Lukmaan IAS. Today we are going to have the Hindu newspaper analysis dated 18th of August 2023. In today's newspaper discussion, we are going to cover important editorial topics and also we are going to cover other important topics that are relevant for the UPSC CAC prelims and mains exam. So with this, let us quickly see the list of articles that we are going to discuss in today's discussion. So these are the list of articles that we are going to cover, and apart from this, these are other articles. So in all, we are going to cover 10 such topics in today's discussion. So let us start the discussion with topic 1. So this was there in the editorial section. This topic is very important because this will give us some idea about registration of births and deaths. So as of now in India, we do have an act which is known as the Registration of Births and Deaths Act 1969. So according to this act, right, there is a Registrar General of India. And apart from this, in every state, there is a registrar, chief registrar. Under that registrar, all the, let's say, deaths and births that happen, it is recorded, right? So the Registrar General of India is the topmost authority, right, at all India level that maintains a database of all let's say newly birth and death. Okay, so this Registrar General of India, under his, let's say, supervision, right, the state governments or like a state similar level authority at the state government, right, so they issue the certificate of birth and a certificate of death also. So recently the government of India has come up with a new bill, and this new bill is going to amend, right, the Registration of Births and Deaths Act 1969. And the new bill that they have proposed, right, is Registration of Births and Deaths Amendment Bill 2023. So in this article has been written by one of the former Deputy Registrar General of India. So this article gives us detailed insight about this particular act. And the author says that the amendment bill has various gaps in it. So we are going to understand about all those gaps that exist in the Births and Deaths Registration Amendment Bill, okay, 2023. So we are going to discuss about it, all right. So here it says what is the purpose? The government of India, while moving this particular bill, they have talked about the purpose of, let's say, amending this particular bill, okay, under a statement of objects and reasons. So they said that the purpose is to create a national and state level databases of registered births and deaths, which could help in updating other databases, resulting in efficient and transparent delivery of public services and social benefits. All right, so this is the objective of the government, means they want to create databases at a state level and at the national level, and these databases will be used by the government at the state level and at the, let's say, national level, right, all India level. So they're going to use this data for providing, let's say, government services and other, let's say, government to implement new policies for the people. So this particular act that we are going to talk about, it's the main purpose is building databases. So the author over here says that although, let's say, government has various departments, right, and most of the departments may be requiring a death or birth certificate. For example, if I talk about schools, right, so they might be needing birth certificate of children, right, for admitting their children into the school. And there are scenarios, for example, the insurance companies, right, insurance companies also require, right, the death certificate of a person in case the person has died and he had a life insurance, right. So similarly, it says that although these departments, right, these departments may get the data from the Registrar General of India once the databases are streamlined, once the databases has let's say data sharing provisions in it, okay. So they will be able to allow let's say allow sharing of data seamlessly among different departments. However, the author points out certain gaps in it. What are the gaps? The thing is if we take the example of certificate of cause of death, right, if somebody dies, right, so let's say along with the death certificate there is a certificate of also for cause of death, and generally these certificates are given in like hospitals. For example, somebody was hospitalized before death, and if that person dies, so the doctor who was treating that person generally issues let's say certificate of cause of death. However, all the deaths do not happen in hospital scenarios, right? Some deaths happen outside the hospitals, where a person who might have visited doctor for any ailment may have been a long duration. Let's say 6 months ago he has visited a doctor for diabetes treatment, for let's say some other fever related issues, but the cause of death was different. In this in this amendment bill, they say that that a medical practitioner who has treated that person very recently should issue the cause of death certificate. However, in all the cases that happens in many different circumstances, many different scenarios, and to provide a cause of death certificate would be challenging, because a doctor, let's say, who has given some prescription for some minute ailments, right, and if that person dies because of some other reason, how that doctor is related, how the doctor would be giving the cause of death certificate. So this is one of the gap that the author has talked about. And also here the author has discussed about one more thing, that here it says other criteria also, that the forms of cause of death are being used in conformity with the World Health Organization recommendations. However, the World Health Organization recommendation does not let's say recognize the Ayush system of medicine. For example, Ayurveda, Yoga, Naturopathy, Unani, Siddha, Suarigva, and Homeopathy. So these systems of medicines, I mean, they are not usable. These system of practitioners, medical practitioners, cannot issue, let's say, the cause of death certificate. So that's also a gap. Apart from this, the author has said that a person who was under treatment for certain diseases can die for, let's say, an entirely different cause that I have already discussed. Then it says, while section 17 of the act prohibits the inclusion of cause of death in any certificate issued under the act, it now says that the cause of death certificate should be given to the relative of the deceased. So there is a contradiction inside the amended, let's say, amended bill itself, okay, amendment bill itself. So these are the things that the author has shared. However, the author shares that we need to look for provisions, enabling provisions, so that all the gaps that are existing here, those gaps can be minimized and the issues should be addressed, right? So this is the message of the author related to this topic. So with this, we will quickly move to the next topic, and before that, let's see if we have a question for practice. So this is one of the question that we are going to solve, right? So this question, it says, with reference to the registration of births and deaths amendment bill 2023, registration of births and deaths amendment bill 2023, consider the following statements. So they have given 3 statements. We need to identify how many of these statements are correct. One, it says absence of birth certificates of a person will be subjected to disqualification of the right to vote. This is not the case, okay? So if I don't have a birth certificate, so I cannot be disqualified from the right to vote, because that's universal adult franchise. Every citizen of India who is above the let's say age of 18 years are eligible to vote, right? So that's the thing. Second, the registration of births and deaths falls under the state list. Third, it says it seeks to amend the Registration of Births and Deaths Act 1969. This is right, this is wrong, okay? So let's see the solution to this. So correct answer is option A, right? So first 2 statements are incorrect, third statement is correct. And if you want to learn more about the amended bill, right, so amendment bill, so you can go through the explanation here and you will be understanding the things related to it. Now with this, we have another topic and we are going to discuss this topic quickly. This topic is related to the Digital Personal Data Protection Act. What? Digital Personal Data Protection Act. So the author says, word choice in the data protection law, a dilution of rights. So here the author says that the government has been struggling for past 5 years to come up with a data protection law in India, right? And similarly, if I talk about the European Union has general data protection regulations. So they have created General Data Protection Regulation and general or this GDPR that actually protects the rights of the users, protects the rights of the people, right? So it protects the privacy of the people. However, if we talk about India, this Digital Personal Data Protection Bill or Act, this particular act actually has been named that it will protect the data of the user. However, if we go deeper into it, right, if we go through the provisions of this particular act, we come to know that like government has chosen the words in such a manner so that like it gives a leeway to the government to use the data of the citizens, right, and they will be able to process data of the citizens in a manner, right, in a manner that that may hamper the right to privacy of the individuals. So in this article, the author has said that the word choice that the government has done in the Digital Personal Data Protection Act that actually hampers the right to privacy of the citizens. So here the author says that in standard situations and the issues, author has given multiple examples. For example, let's say like if you go to a showroom, right, and that showroom says like fill up this survey form. If you fill that survey form, so like what you have done, you have consented to giving your information. You might have entered your number, you might have entered your email ID, you might have entered your phone number, let's say like name. So these data are captured. So like you have voluntarily chosen to give your information to the, let's say, retail store or to the showroom, and after then this retail store and showroom can share it with anyone else, and like it will be presumed by the authorities, government authorities, that like you have voluntarily consented to giving your personal information to the store, and after then they will be able to utilize this data for any other lawful purposes. Okay, so it has a mention of this particular thing, that like if you have voluntarily chosen to give your data and you have not indicated, okay, have not indicated like any refusal, okay, if you have not indicated any refusal or non-consent, in that case it will be considered that you have given your consent. That's the thing. So apart from this, the author talks about that there are many areas of concern related to this. What are areas of concerns? For example, what is more, when your data is processed without consent, you will neither be notified nor notified of this subsequently be able to confirm it. Means, for example, a data you have given to one organization that will be can be shared by that organization to another organization, and in that case they are not going to notify you that like we have shared this information to that organization. And also government can take that data from the private entities, right? In that case also government is not going to notify. So the thing is like you do not have a consent, like you did not receive any notification that your data is going to be shared by this with this organization. And also you will not be having any authority, right, let's say to get something modified over there, or let's say like delete some redundant data from there. So these are the, let's say, these are the areas that this particular Digital Personal Data Protection Act misses upon. Okay, so you need to understand about, let's say, some of the criticism of the bills or acts that like government of India has come up with, so that like you can have a sound opinion about various issues related to this. So with this, like we will move to another topic quickly. This topic is again related to some of the bills that have been introduced in the parliament by the central government, okay, by the Minister of Home Affairs. So we are talking about the bills that are going to amend or that are going to repeal the existing Indian Penal Code, the Criminal Procedure Code, and the Indian Evidence Act. Okay, so which bills are we talking about? We are talking about the Bharatiya Nyaya Sanhita Bill. Okay, so Bharatiya Nyaya Sanhita Bill is going to replace the Indian Penal Code. Then we have Bharatiya Nagrik Suraksha Sanhita Bill. Okay, it's going to replace the Criminal Procedure Code. Apart from this, we have Bharatiya Sakshya Bill, which is going to replace Indian Evidence Act. All right, so here one of the, let's say, editor of the Hindu has interacted with two persons. One of the person is a former IPS officer, and other person is an advocate of the Supreme Court of India. So this is an edited excerpt from the interview that they have conducted. So in this article, what they do is like they try to get answers of some of the questions like how different are the new bills different from the prevalent laws, okay? Means the new bills that they have introduced, how different it is. So it is different in many ways because the sections that were mentioned in the Indian Penal Code, right, the sections, so these sections have been jumbled up, okay? One thing is these sections have been jumbled up. This is one difference. Apart from this, like they have defined some of the new or noble new like offenses. For example, the offense related to cow vigilantism, the offense related to terrorism, the offense related to organized crime. So they have defined these offenses, and apart from defining, right, what they have done is like they have included them into the provision of IPC, CrPC and Evidence Act also, okay? So this is how it is different. And also, like if I talk about, right, here they have allowed the police officers to handcuff, right, to handcuff people. So you can see an image of handcuff, right? So it has now been made legal that a person can be handcuffed by the police officials. And apart from this, like, you know, in India, earlier there was a provision that like a person can be detained, a person can be, let's say, like, you know, kept in custody by the police officers for about 60 days. Now it has been increased to 90 days. And if I talk about some other countries, they have given example of one country over here, for example, Scotland. So in Scotland, right, the amount of time for which you can keep someone in detention without bringing charges against them is only 6 hours, right? So in Scotland, you can detain a person without bringing charges against him for 6 hours only. And in India, we have, let's say, gone in a different direction, altogether opposite direction. We have increased it to 90 days, okay? So these are the changes that the new bill, let's say, is going to come up with. And apart from this, second question that they are answering is the new Bharatiya Nyaya Sanhita allows a custody from 15 days which can go up to 90 days. As a former police officer, do you think it is needed? So here, like, you know, they have talked about many cases, previous cases where the Supreme Court of India has given judgment that here they have also talked about, like one of the Supreme Court judgment is related to DK Vasu versus State of West Bengal, okay? So in that case, the Supreme Court of India categorically said that like you cannot handcuff a person. Apart from this, like, you know, so right to handcuffing has been mentioned, and also, like, you know, this provision of increasing the thing. So like they have said like it is not needed that like you can, let's say, like, you know, like you can ask for custody of a person till 90 days, okay? So this is the thing. Apart from this, they have also answered a question which is related to what would you say are the similarities between the existing laws and the new bills, okay? So what are the similarities? Similarities is that most of the previous offenses that were mentioned in the Indian Penal Code, Criminal Procedure Code, Evidence Act, so they are part of the new thing also, okay? So it's something like old wine in the new glass, okay? However, there are some changes as well, changes in the nature of the new like, you know, offenses that have been let's say like mentioned in the newly introduced bills. For example, organized crime, terrorism, etc. Okay, and also here, like, you know, here, like, they have made one difference, like, you know, one difference is earlier rape related thing has been mentioned, in such a manner that a person, right, like, you know, so rape was considered to be, let's say, a man doing let's say sexual atrocities against a child, so that was considered to be a rape, let's say, against a woman. But here they have only categorically mentioned about rape against women only, okay? So, like, you know, that needs some changes, because here, like, you know, like it says, they say that has the government forgotten about sexual offenses perpetuated by man on man or women on women, okay? So these are the things. So are there welcome changes in the new bills? Okay, so they say yes, there are certain welcome changes. However, they also suffer from many things, because this Indian Penal Code, it has been 164 years that, like, the Indian citizens and the judges and the lawyers, they have been accustomed to. For example, everybody of us knows that, like, section 302 talks about murder, means like offenses related to murder. Then there are certain sections that, like, all of us know, and section 422 is related to let's say fraud. Then we have section, so these sections are going to be meddled with. So the author says that these changes are not good, because, like, the sections should have been retained in that manner. Okay, so this is the thing. So with this, like we are going to move to the next topic. So what is the crux of this topic? The crux of this topic is these bills will be introduced, has been introduced in the Lok Sabha. There will be debates on it, and we still need to wait and watch how, let's say, different parliamentarians are going to take, have their take on this, and whether these bills are passed. And once these bills are passed, like, what will be the a stand of the judiciary, right? Where will there be cases filed against it in the judiciary? Okay, so we need to wait and watch related to this. Okay, now, so we have a question for you. This question says, what are the recent changes done in the CrPC Act? Okay, Criminal Procedure Code Act. How is the new bill different from the previous law? You need to answer this question in 150 words. So remember that they have come up with 3 different bills, one that changes the IPC, other that changes the CrPC, and the third that changes the Indian Evidence Act. So this question is related to the CrPC only, right? Criminal Procedure Code, right? So with this, we have another topic. It says, now drones to monitor progress, quality of assets produced at MG Narek's work site. Okay, so what is MG Narek's? It is Mahatma Gandhi National Rural Employment Guarantee Act. Okay, so this Mahatma Gandhi National Rural Employment Guarantee Act gives guarantees to rural households that they can ask for 150 days of work in a year, right? So the government will give them work, and, like, that will be manual work. So in that case, like, these people will be made to let's say, like, make some infrastructure, social infrastructure or economic infrastructure. So recently the government has decided that they are going to allow the drones to monitor the progress, right? Monitor the progress of these MG Narega work sites. Okay, for that they have done some changes into the existing drone policy. Okay, so this topic is related to that, right? So it's about changing the drone policies for enabling this, inspection of MG Narega work site. So we have a question related to this, so we are going to look into this question. It says, right, with reference to the unmanned aerial vehicle, consider the following statements. We have, let's say, 4 statements. It says it is regulated under the ambit of Ministry of Civil Aviation. This is right. Second, it includes a ground-based controller and a system of communication, unmanned aerial vehicle. This is also right. The requirement of UAV license has been abolished. This is also right. Fourth, Kerala is developing the nation's first common testing center for unmanned aerial vehicle. It is not Kerala, right? It is, I think it is Tamil Nadu. So, which of the above statements are correct? Option C would be the right answer. 1, 2 and 3 only. Okay, 1, 2 and 3 only would be the right answer. So you can go through the explanation in your free time, right? You can download the PDF from the description. So with this, like, we have another topic. This topic says NAP a flexible policy, states free to adapt according to their requirements, right? So NAP means National Education Policy. Okay, NAP means National Education Policy. Okay, National Education Policy. So the government of India has come up with National Education Policy 2020, and recently the Finance Minister of India was attending a seminar somewhere, and there she has mentioned that national education policy is a flexible policy. It allows different states to interpret this policy according to them and adapt, right, the provisions of national education policy that let's say meets their requirements. So the thing is, like, the finance minister of India has said that it is not a one size fits all approach. It's a, let's say, broad umbrella that has been given to everybody, so that like every state can use its provisions, right, for enhancing their educational standards, right, in their schools, right, in those states, in let's say primary schools, secondary schools, and higher educational institutions as well. Okay, so like related to this, like they have also mentioned about some of the quotes of the education minister, Mr. Dharmendra Pradhan, and also the NCERT director has also mentioned that as per NEP, all students from the ages of 3 to 8 will get education in the mother tongue or home language. Teachers will be encouraged to adopt a bilingual approach with those students whose language could be different from the medium of instruction. All right, so these are the things. So like this is an enabling provision. So this national education policy has come in 2020. However, it is being implemented across India, right? So the pace of implementation is little slow because many states are still understanding, right, understanding like what are the things that they need to adopt, what are the things that they do not need to adopt. So now we have a question on this. It says, what is national education policy? Discuss the importance as well as criticism against national education policy. Okay, so this is the thing we need to discuss, importance as well as criticism. So you need to write this question in about 150 words, right? So with this, we will move to the next topic now. So this is the next topic. It says Chandrayaan propulsion lander module separate. Okay, so as we all know that Indian Space Research Organization has launched the Chandrayaan 3 mission on 14th of July 2023. So it has been about 34 days that we have launched the Chandrayaan mission. It's been more than a month. Now Chandrayaan mission, this Chandrayaan 3, it has reached the moon's gravitational field, right? It has reached the moon's sphere of influence, and after then, now they have, during this process, what they have done multiple maneuvers so that the Chandrayaan could be, Chandrayaan 3 could be, let's say, sent to the moon. Now this lunar mission so far has been successful, and now they have been able to separate the propulsion module and the lander module. Okay, so the propulsion module was something that has carried the lander module so far, and this lander module in itself, right, inside the lander module, let's say this is the lander module. Okay, this is the lander module. So inside the lander module we have a rover also. So once it soft lands on the south pole of the moon, right, then the rover will come out of the lander, and this rover is going to roam on the surface of the moon. It's going to collect data, and it is going to share this data with the orbiter of Chandrayaan 2 mission, because the previous Chandrayaan mission, which is Chandrayaan 2 mission, that mission's orbiter is functional. That mission's orbiter is successfully functioning. So it's going to share data there, and from there, like India is going to receive, ISRO is going to receive the data. So related to this, you need to learn the entire trajectory, what Chandrayaan 3 followed, the path, and also you need to learn about the objectives of this mission. So we had 3 objectives of Chandrayaan 3 mission. One of the objective is to demonstrate India's capacity of soft landing on the south pole of the moon. Second objective was to demonstrate the capability of a rover to roam on the surface of the moon. The third objective was to conduct in situ scientific experiments on the surface of the moon. So these are the 3 broad objectives with which the Indian Space Research Organization has sent the Chandrayaan mission, right? So we need to, let's say, keep a tab on the recent developments related to this, so that we understand how a lunar mission of India, successfully works and brings the prestige of India, right, much ahead as compared to any other country in the world. All right, so this is one of the, let's say, flagship mission of the Indian Space Research Organization. All right, so this is the thing. So with this, we came to another topic. This topic is related to Indian economy. So it says, supply shocks not over. Inflation to be well above 6% in quarter 2. Okay. So now we need to understand about supply shocks. Now, what is quarter 2? Quarter 2 means, let's say financial year start from 1st of April, okay, till 31st March, the financial year happens. So 1st of April till let's say June, that was quarter 1. Then after June, right, till let's say August, September, we have quarter 2. So now quarter 2, in quarter 2 of this financial year 2023-24, so the inflation are expected to be well above 6%. Why it is to be well above 6%? Because supply side, right? So one is demand side. Demand side means where people demand goods and services from the economy, and there is a supply side. Supply side means those people who produce, those people who sell, right? So they are part of supply side. So in supply side there are constraints, okay? There are constraints. Constraints means there are difficulties from the supply side to meet the demand side requirements, okay? To meet the demand side requirements. So that's why when supply of goods is low, in that case demand is high. So generally the price of goods and services goes up. So that's why let's say there will be inflation, right? Inflation above 8% in Indian economy. All right. So that's the thing. So here they have mentioned about that another upside risk is crude oil prices. They note, citing the OPEC plus production cuts, okay? Organization of Petroleum Exporting Countries, they have also cut down the production of oil, okay? They have cut down the production of oil, and for that reason also, there are causes for increasing in inflation. It also says there is a diminishing probability of crude price pressures easing over the rest of the year, they add. So these are the things. They also note core inflation eased in July, extending a softening bias, okay? So these are the things, I mean, it's related to Indian economy, it's related to inflation, okay? So related to this, you need to learn about what is inflation, what is disinflation, what is deflation, what is stagflation. These are some of the terms that we encounter in economy, okay? Many a times UPSC asks questions in the prelims exam from these concepts, right? So we have a question also for you. So we are going to solve this question. It says, which of the following statement correctly describes stagflation? Okay, stagflation. So stagflation means it is a combination of high unemployment and high inflation, okay? When the inflation is high, means prices of goods and services are high in the economy, it becomes difficult for a common person to purchase, and at the same time that person is also unemployed, okay? So increasing unemployment with increasing inflation, it leads to stagflation, okay? So economy, let's say, shows a stagflation trend then. So correct answer is option C in this question. So with this, we have another topic. This topic is again important. We are going to discuss about this topic. It says, WHO chief asks nations to unlock power of traditional medicine, okay? WHO means World Health Organization. Its chief has recently asked, right, different nations to unlock, right, to unleash the power of traditional medicine. So traditional medicine system, right, in India we have Ayush medicine system, okay, which forms the traditional medicine system. So it stands for Ayurveda, Yoga, Unani, Siddha, Homeopathy, and also it has Naturopathy and Soa Rigpa, okay. So these are traditional medicine system, and in India we have established, right, WHO's Global Center for Traditional Medicine, okay. So this has been established in Jamnagar, Gujarat. So here the WHO, World Health Organization chief has visited, and he has, let's say, inaugurated this, and he has talked about that, we need to strengthen the traditional medicine system across the world, okay. So this has been, warmly accepted, right? This message has been warmly received by India, because India is also putting so much effort, right, to bring the Ayush system of medicine at par with the, let's say, at par with the modern system of medicine, allopathic system of medicine that we have, right? So this is the thing. So with this, we have another topic. It says that the Chief Justice of India asks, if petitioners want Supreme Court to assess government's wisdom in repealing Article 370. So all of us know that the central government of India has abrogated Article 370 in 2019. And after abrogating Article 370, what they have done, they have, let's say, they have taken away the statehood of the state of Jammu and Kashmir, and it has been converted into two union territories. One is Union Territory of Jammu and Kashmir with a state legislature, and then Union Territory of Ladakh without a legislature. So they have created two union territories. And so that particular incident, right, has followed there are certain chronological events. Initially, the central government of India has, let's say, imposed president's rule in the state. So after imposing president's rule, a state legislative assembly stopped functioning. The president of India has assumed the power of the state, state legislative assembly, and then they have, made certain changes, related to Article 370 of the Constitution, that is connected with the Constitution of the state of Jammu and Kashmir, and then they have abrogated this particular thing. Now, there are petitioners from the state of Jammu and Kashmir, from the erstwhile state of Jammu and Kashmir, who have filed cases in the Supreme Court of India. And they are, they are giving their points, right, to the Chief Justice of India. And Chief Justice of India is part of the constitutional bench, okay. So recently the Supreme Court of India said that whether the petitioners want the Supreme Court to assess government's wisdom in repealing Article 370 or not, okay. So this is related to that. There are some, points that are made. So these are part of the hearing that has happened in the Supreme Court of India, okay. So these are part of the hearing. That's the thing. Now we have another topic. This topic is very, very important, okay. So this is important for the prelims exam. It can be considered as part of internal security, or you can consider it to be part of science and technology. So this is a topic that has been in news. It says the President Murmu launches warship, Vindhyagiri, okay. So the President of India has launched this warship Vindhyagiri. So this warship has been built, right, by Kolkata-based Garden Reach Shipbuilders and Engineers Limited. So it is a ship of Indian Navy, right? And when the President of India has launched it, then she has talked about the importance of Indian Ocean region. So the Indian Ocean region is a region, right? Is a region in the Indian Ocean that the government of India wants to safeguard its security. So we want to protect the security and freedom of navigation in the Indian Ocean region. So that's why we want to bring Indian Ocean region out of any piracy related issues, okay. And so she has talked about the importance of Indian Ocean region, and she has talked about the larger Indo-Pacific region, right, and its safety and security. She has also highlighted about the roles that Indian Navy has been playing in safeguarding the maritime border of India. So what is important is you need to learn the name of this particular ship, which is INS Vindhyagiri, okay. So it is a warship. What is this? It is a warship, naval warship. So that's all in today's discussion. Thank you so much everyone for attending today's session. I hope you have a good day ahead. Thank you.